Hello? What's going on? Is there anyone hearing? What is with the audio? Alert volume. Is the audio working? Is the audio working? Open your settings to unmute mic level and adjust its level. Right here.
All rise. The Court of Davidson County will now transact the business for which it was created. All persons having business before this court draw near, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Senior Judge Vanessa A.G. Jackson presiding. Please be seated.
Good morning, everyone.
Morning.
Happy holidays to you. All right. Good morning, Mr. Greenberg. Can you hear us okay?
I can hear you, but you can't hear me?
Yes, Your Honor, I can.
Okay.
I can't hear.
I think there might be two Mr. Greenbergs on here. All right. You may have us muted, Mr. Greenberg.
Hello?
No,
Okay.
we cannot hear you.
But you can see me. Open your computer settings, unmute it, and adjust its level.
Can you hear us now, Mr. Greenberg, or we can't hear you?
I can't hear, you can't hear me.
Do you have us muted, Mr. Greenberg?
I pressed unmute. Hello?
Your Honor, this is Mitchell Greenberg. I just want to make sure you're not asking me, but you're asking Daniel Greenberg these questions.
Yes, that's correct. I'm speaking to Daniel Greenberg. He is the one we can hear you fine, Mr. Mitchell Greenberg.
Okay, thank you.
Hello? Can you hear me?
Are you making any progress, Mr. Greenberg?
I'm trying.
In unmuting us?
No.
Any suggestions, ladies? Okay. Mr. Greenberg, do you want to try to log out and come back in and see if perhaps that would help?
Okay.
Can you do that?
Yeah.
Okay, thank you. We may have lost 2%. Here we go. All right, we have you back, Mr. Greenberg. Can you hear us?
I can hear you. Can you hear me?
We cannot hear you.
My audio says it's muted.
Yeah. Mr. Greenberg, if you, do you want to, does he have a number to call? Do you want to give him? Okay. Mr. Greenberg, I've been instructed that if you were to call in on the number that you have, we could hear you.
Is it working now?
It is working now. Great. All right. I think then we are ready to begin.
All right. Well, is my brother on?
He is.
I don't see his picture. Is he dialed in or what's?
I'm not sure. We can hear him. I'm not.
Your Honor, I am dialed in. For some reason, the software's not working. If someone can email me the link, I can try on my computer versus my phone.
Yeah, it's important.
But you can hear us, and we can hear you.
Here's the link, Mitchell. I sent you the Zoom link.
Okay. All right, ladies and gentlemen, before we begin, I want to make a preliminary statement. Just a minute, Mr. Greenberg, and we'll begin the hearing. There's a preliminary issue that I need to address. I am aware that Mr. Daniel Greenberg has filed a suit in the Federal District Court for the Middle District of Tennessee, in which I believe, although I have not been served with any process, that I am named as a defendant along with some other persons. I really have no knowledge of the case other than the fact that I'm aware that it probably has been filed. I don't have any knowledge of the allegations contained in the complaint against myself or any of the other defendants. I will say that I believe this is just another attempt by Mr. Daniel Greenberg to judge shop or forum shop, as we have seen in the past. If Mr. Greenberg doesn't agree with something that a decision a judge makes, he files suit against that judge. He did that in this case. He was very unhappy and dissatisfied with the decisions of the trial judge and the appellate judges in California who presided in his divorce action there. So when this interpleader action was filed in Tennessee, he filed a cross complaint in cases 23-1069 and 23-0224. And he also was dissatisfied with the decisions made by Judge Joe Binkley and Chancellor Woodruff, and he filed cross complaints against them as well. I'm talking, Mr. Greenberg, you can wait for a moment. His claims were dismissed because they were without merit. In fact, they were frivolous. He's been dissatisfied with my rulings in this case. He has previously filed motions for me to disqualify or recuse myself. I have denied those motions, and now apparently he has taken another approach, and that is to file suit in federal court. Again, I have no knowledge of what the allegations are in that complaint.
That's not true.
Throughout this hearing, I have tried to be courteous and understanding with Mr. Greenberg, realizing he is a pro se defendant, and perhaps we have given him some latitude that we would not have given an attorney in this case. I have no concern about my ability to be fair and impartial in this matter. I have made and will continue to make my rulings based solely on the law and the evidence that is before me in this case. I have consulted with the ethics attorney for the judicial conference. I have read a couple of cases, one in particular, Maher versus DPR, which is a reported case in 406 Southwest 3rd 139. There is also an unreported case that is Solis versus, I think it's Duchester or something like that. I can give you the site on that case if you like it. In those cases, the appellate courts in Tennessee have held that a disciplinary complaint filed against a judge by a party to a pending lawsuit will not by itself warrant a recusal of that judge. And that requiring a recusal in those circumstances could foster and encourage abuse of the judicial system by encouraging people to judge shop or forum shop and manufacture recusals. In this case before us today, Mr. Greenberg has not brought forth any showing of bias or prejudice in this case on my part, and therefore I will not disqualify myself. I do have the site, on that unreported case. It is, I'll spell the last name or the defendant's name, because I can't pronounce it properly, but it's ROSDEUTSCHER. It is a 2021 case and can be found at Westlaw 830009. Having said that, we are now ready to begin the proceedings. The first matters that we have on the docket.
Yeah, I have an objection to what you say and recall and request that you immediately recuse yourself.
Your objection is noted, Mr. Greenberg. Your objection is noted, and we're ready to begin.
Okay, your previous involvement in these other cases requires that you recuse yourself. As also your assertion.
I ruled on that, Mr. Greenberg.
Yeah, you don't get to determine whether or not you're.
Please mute him. All right. Motion for summary judgment. In this case, I believe we have several filed by Ms. Carla Greenberg. Is that correct?
I filed one.
Sorry, Gifford. All right. Let me go ahead and just make a list of the folks we have here and what you are here for today. I recognize counsel at this table, but let me go ahead and have you introduce yourself, sir.
Adam Barber for the estate of Mary Weiser.
Okay, Mr. Barber for the estate. All right.
Dr. Daphne Davidson, Senior Associate Counsel at DHS, Ada, Tennessee.
Okay. And I'm sorry, could you give me your last name again?
Davidson.
Davidson. I'm getting old and my hearing isn't as good as it used to be.
Julie Gander, Your Honor, he's Mono, who represents the Village of Cherry Glen Association.
All right. Yes, sir.
Judge Jackson, I'm Timothy Palmer. I represented Dean Guthrie and Gonzalez in the case. I'm really just trying to find out the disposition of the process.
All right. And yes, sir, and at council table here, just for the record, if you'll introduce yourself.
Nicholas Bellamy, I represent Carla Gifford.
I know who you are, but for the folks that are in the courtroom.
John Maher for Carla Gifford, Your Honor.
And of course, as you know, we have Mr. Daniel Greenberg, who is representing himself, and Mr. Mitchell Greenberg, who is here.
Yes, Your Honor. I also have a motion for summary judgment as well as your.
And you have a motion, yes, sir. And we will take that up in due course.
Can we not hear mine first? What's the prejudice towards having heard
No, I'm
first?
going to hear them in the order that we have just talked about. I'll actually hear Mr. Bellamy and Mr. Maher first, and then we'll go with whoever else has something pending. Only thing I'm showing is motions for summary judgment. Your motion for summary judgment, motions for summary judgment filed by Carla Gifford. Anybody else got a motion for summary judgment
I
that
do.
I don't have on my list today?
I do.
You do, Mr. Greenberg. Yes, I said we got yours. We'll hear from you as well. But I'm going to hear the motion for summary judgment filed by Ms. Gifford first.
Okay, and how are we going to handle my objections to his assertions?
Morning, Your Honor. John Maher. With regard to the Cherry Glen Homeowner Association, we've discussed that with them, and we'll enter an agreed order satisfying their lien. That's in regard to case number 231069. And that one, the motion for summary judgment against Cherry Glen will enter agreed order satisfying Cherry Glen's lien on the property. Sweet Cherry is the main property in that one.
Okay.
So we'll integrate order on that one.
All right.
With regard to Sweet Cherry, with regard to the motion for summary judgment against the state of Tennessee there's a child support lien, and I've discussed that with the state. It only goes towards any money that Mr. Greenberg would be entitled to. With regard to Sweet Cherry, it's our position that our client based on the domestication of the foreign decree, she receives 100% of that property. So there's nothing that Mr. Greenberg would receive of that property, and therefore the state's liens will only be on Mr. Greenberg's portion of that, and I think the state agrees with that.
All right.
So
if anyone doesn't, I'll give you an opportunity to speak, but it sounds like you've worked those things out.
then with regard to Mr. Daniel Greenberg, with regard to the Sweet Cherry property, again, we have domesticated the foreign decree that was domesticated on April 19, 2024. She is awarded 100% interest and rental profits by the California decree, which has been domesticated. Therefore, there is no issue with regard to that. Any issues that Mr. Greenberg brought up in his response, or Mr. Daniel Greenberg, I'm sorry, brought up in his response are raised judicata. These things have already been decided. We've already domesticated the order. Any issues he had would have been brought up in the domestication petition, and he's bringing up the same arguments here that he did.
That's not true. That's false.
And the court's already made
Objection.
those determinations. Next, we go to Ackland Avenue. With regard to Ackland Avenue, Mrs. Gifford, again, domesticated the foreign decree, April 19, 2024. She was to be paid 50%, or she's a 50% owner of that property. That property was to be sold, and out of that was to be satisfied to her, her judgment, money judgments against her. There are multiple money judgments. There's a $66,724 judgment for attorney's fees awarded to her against Mr. Greenberg's interest in this property, as well as $30,000 in sanctions and $164,321 as a result of his violation of atros, removing various assets and co-opting those. So with regard to that, there's only $297,000 available in that account. $148,000 of it would be surplus funds that Mr. Greenberg would be entitled, and with the $161,000 simply as the damages for the accounts and the rents exceed the amount of the surplus funds. So it's our position that 100% of that funds should go to Mrs. Gifford. In this case, again, the state of Tennessee's lien with regard to child support is for any excess funds that would be paid to Mr. Greenberg. In this case, there are no excess funds for the state to receive. And that's basically our position with regard to that, Your Honor. And we briefed all that in
You have, thank you.
specifics.
Thank you. The defendants that are in the courtroom, I'll give Daniel Greenberg an opportunity to speak momentarily, but for those who are here present tonight, is there anyone who wishes to address what has just been presented to the court?
Yes,
I
I do.
did forget, Your Honor, there was previously an estate lien on the property, which was again resolved in a separate proceeding. And it looks like that estate deed was declared void, or the deed of trust that the state had on the property was declared void on March 28, 2024. After hearing, I believe the estate has filed a response on that, Your Honor.
Thank you. All right. Anything further from any of the parties here in the courtroom? Yes, sir, Mr. Barr.
Good morning, Your Honor.
Good morning.
I just want to confirm what Mr. Maher said. The deed of trust was already litigated, adjudicated, and that was declared void earlier this year. So the estate has no longer a good faith effort in moving forward with the deed of trust, Your Honor.
We appreciate your input. Thank you. All right. If there's nothing further from those folks that are in the courtroom, is Mr. Mitchell Greenberg is your client? Is that correct? He's the administrator of the estate, and he is here present, at least through the audio portion that we have today. All right, Mr. Daniel Greenberg, it's your opportunity to address what has been said by the attorneys in court today, and also to present your motion for summary judgment.
Okay, so my first request is your immediate recusal based on your previous involvement in other cases, 20D717, this case, and 1069.
Well, I've overruled that, so you can move on.
Okay, I'm not sure that that's appropriate for you to overrule that, but okay. So as this court is aware, I asked that judicial notice be taken on the fraud upon the court that was used to obtain the order that you domesticated in 20D717, and that issue has never been properly litigated, as you have rubber stamped fraud. So you're perpetuating the fraud does not constitute a valid order. I understand that that's your position, that it's not void, but we're here to have a jury decide what material facts exist. And the fact that that was an order procured by fraud is a fact of material dispute. And that is necessary for us to determine. But even though I've already given you the information to determine that fact is true,
Mr. Greenberg, I have dismissed your counter and cross complaints in which you made those allegations. I have ruled on that in the past. The only thing that is still pending before this court is the original interpleader action.
right. And what you don't understand is that's not how fraud works, and ignorance of the law is not an excuse for mistreating me. I mean, I've in my memorandums, I've explained exactly how this is supposed to go. Would you like me to go over it again? Also, I've received information that the estate attorney has not even communicated with the executor of the estate. That seems somewhat suspicious, but that's neither here nor there. I'm here to present my motion for summary judgment. So on June 6th, 2017, sua sponte appointment of a guardian ad litem. Once that occurred, all resulting orders stemming from that that order were void. Even the made of property income stuff that they were talking about, that is supposedly res judicata. Res judicata does not exist when fraud has occurred. I mean, do you need me to read you the case law that states that specifically? Or are you in agreement that that's what's true? Your Honor, you're not going to comment, or?
No, sir, I'm just letting you make your argument.
Okay. Well, I'll find it and read it to you so it's on the record. As held in Bullock v. United States 763 FD 115 121 10th Circuit 1985, fraud upon the court occurs when the judicial machinery itself has been corrupted, and it is not merely between the parties or by a single party, but a scheme calculated to interfere with the judicial machinery performing the task of impartial judgment. Material facts preclude summary judgment for defendants. The Rankin Court reversed summary judgment, finding that there are questions about the judge's knowledge and intent regarding jurisdiction, as well as possible improper motivations for appointing a guardian. Summary judgment is inappropriate. Here too, there are material facts of factual disputes about Julie Palafox having the authority to appoint a guardian ad litem, which she did not. A void judgment cannot constitute res judicata. Denial of previous motions to vacate a void judgment could not validate the judgment or constitute res judicata. For that reason, the lack of judicial power inheres in every stage of the proceedings in which the judgment was rendered. That means all those proceedings that took place in the third interplater are null and void, just as much as all the actions that you've taken in these cases are null and void. There's no way a judge gets to say something's valid when on its face it's already invalid. There's no hearing you can conduct to say that it's valid. I understand that's what you're doing and have done, but that's not the actual law. I would like to go back to how you opened this hearing with your assertions that I was judge shopping or unhappy or some of that stuff, but it is a constitutional right to actually attack void orders. And you seem to be thinking that because I'm disgruntled, that means I don't have that constitutional right. When in fact, a void judgment grounds no rights, forms no defense to actions taken thereupon under, and is invulnerable to any manner of collateral attack. No statute of limitations or repose runs on its holdings. The matters thought to be settled thereby are not res judicata, and years later, when the memories have grown dim and rights long been regarded as vested, any disgruntled litigant may reopen the old wound and once more probe its depths, and it is then as though trial and adjudication had never been. Are you in agreement or disagreement with that established law? That is Fritz versus Michigan, 1958. This has been in effect since 1958, and you're acting and you're officiating in a manner then consistent with that. That's not me being dissatisfied. That's not you adhering to the law. Further, in Tennessee, orders that are void ab initio are not entitled to res judicata preclusion. Void orders have no legal effect from outset. McLaughlin v. McLaughlin, 2020, 10, appellate Nexus 572. Further, if a court lacks jurisdiction, any resulting judgment is void and to a collateral attack. Tennessee courts have held that void judgment is one that shows upon its face a want of record jurisdiction in the court assuming to render a judgment, which may want of jurisdiction may be either of person or of subject matter generally, or a particular question attempted to be cited or relief summed given. So, again, we're down to the matter where there are facts of material dispute, whether or not the orders that were adjudicated and then subsequently domesticated by you, who is not an impartial party, were actually void, and I have a right to present evidence to a jury that those things are void, and you're not allowing me to do that for whatever reason. I mean, I know the reason, but the third party is entitled. Now I'm entitled to summary judgment because of the very things that you're denying actually occurred. The guardian ad litem appointment was made without notice or hearing. There was no competency hearing conducted. The appointment was made sua sponte. The appointments terminated my ability to present evidence. The transcripts revealed the appointment was made in response to legitimate legal advocacy. As established in Rankin, ex parte guardianship proceedings constitute flagrant violation of due process. The Wellman's Court warning remains in point. Without notice and hearing, no citizen would be safe from the mechanizations of secret tribunals, and the most sane members of our community might be a judge sane and landed in the madhouse. And that's exactly what's happened here. You got people that were caught with fraud. They didn't provide the discovery that I asked about the fraud that they committed, and now you're going to hand over my estate and my mother's estate based on fraudulent information, fraudulently obtained order. Now, assuming that you're not going to grant me my motion for summary judgment, I am willing to have a trial by jury to adjudicate these facts and determine which facts are true and which facts are not, and the conclusions of law that should stem from those facts. The filing of my cross motion for summary judgment does not deprive the court of its responsibility to determine whether or not there are genuine issues of material fact to be tried. It's a little peculiar that in this instance here, that the homeowners association decided to come in and cut a deal with the other party to get paid so as to not proceed with their motion for summary judgment. That seems a little backhanded, and I guess will have to be pursued at some other point. I mean, she can't validly obtain motions for summary judgment when that is in dispute. I mean, that is still in dispute, so what else is there? So the fact that both parties have moved for summary judgment does not mean that the court must grant judgment as a matter of law for one side or the other. When faced with cross motions for summary judgment, the court must evaluate each motion on its merits. So I am requesting that should the summary judgment not be granted to me, third party, immediate scheduling of a jury trial to determine the materially disputed facts be scheduled at this time. In addition, an order permitting additional discovery and presentation of witness testimony regarding extrinsic fraud and collusion by defendant Gifford and other third-party defendants and her counsel and other parties involved in these proceedings be allowed to occur. Lastly, like I said, you need to recuse yourself. I object to your participation in motion for immediate recusal. This was brought to your attention prior to any of these proceedings taking place. You're presiding over 2302241 and 231069-3 due to previous participation, and you're in 20D717 involving domestication of the foreign decree. This creates an insurmountable conflict of interest and constitutional violation. Basically, because you said that the California divorce decree order is valid, I'm coming in here and saying that it's not valid. How is it that you're not biased to you can't rule against yourself? You've already said that it's not invalid, but I have a right to come in each instance and say I'm contesting the validity of this order as the case law indicates, and you're denying me that. And the only proper remedy for due process is due process, and that would be a trial. So we need to have a trial. Further, a constitutional right to an unbiased tribunal. The Supreme Court has consistently held that a fair trial in a fair tribunal is a basic requirement of due process. So I've already described to you what you've done is not a fair trial. And now the Supreme Court is saying to you that you need to provide me with due process, and you're not allowing me to have that due process is problematic. Further, your denial that you don't know of these very things that are part of the petition in federal court. They're right here. You can't not know what it is that is right here as to what is being alleged against you. There's inconsistencies in your logic. Right there, you've already defaulted yourself. Like, I've acknowledged that I've alleged, acknowledged, asserted that you're unbiased because you're participating in 3 different cases. You are participating in 3 different cases. The Supreme Court says that that's constitutionally intolerable, and yet you still proceed as if that's not true. So you're just committing fraud. You're acting outside your jurisdiction. Committing crimes are not judicial acts. But leave that there, as this situation mirrors the concerns raised in Rankin v. Howard, where the court held when a judge knows that he lacks jurisdiction or acts in the face of clearly valid statutes or case law expressly depriving him of jurisdiction, judicial immunity is lost, which is what I was referring to above. You clearly have abandoned all due process so that you can push these orders through. And that's not a judicial act. That's you committing fraud. We can have a trial that actually spells that out, or we can all just, as adults, accept that those are the facts that have occurred, the events, and those events lead to that conclusion of law. Okay, now, your predetermined, I hinted at this earlier, your predetermined outcome violates due process. And when I say that specifically means when you decided to domesticate 20D717, that meant when you came in here and put on this robe in this court, you already had a bias to say that whatever attack I made on any orders would be biased by the decision that you'd already made in a previous proceeding. Again, that's constitutionally intolerable. You know this. All your friends in the courtroom are pretending that they don't know this and are getting paid handsomely to go along with the ruse, but it's still established that without notice or a hearing, no citizen can be safe in the machinations of the secret tribunals of Wellman, Kansas appellate. Jackson's continued participation amounts to conducting a sham hearing with a predetermined outcome, as she cannot reasonably be expected to rule against her own void orders. All right, so I need to take a break to gather my thoughts. I would like to take a recess, and in 5 minutes I will continue with the rest of my summary judgment. Thank you.
Mr. Greenberg? Ladies and gentlemen, the hearing is, I'm not granting a 5-minute recess. Sorry, I don't need it. I think that the briefs filed by the parties are sufficient. Quite frankly, I probably could have ruled without oral argument in this case, but I appreciate you being here. I think that since I'm in different counties, every county does it a little differently, but I believe, Ms. Hollis, you want the orders sent to you, any agreed orders, and then you will alert me of that. Is that correct?
Either submit those orders electronically to the system or over the counter.
All right, so when you have prepared your agreed orders, as you heard, just get them to the clerk's office and they will make sure that I'm aware of it, and I'll look at those. With regard to the contested orders, or the contested matters, which deal with your motions for summary judgment and Mr. Greenberg's motion for summary judgment, I don't know if you want to respond to Mr. Greenberg's since he's not in president, I'll even wait 5 minutes and let you, he's back again. Let's see.
And I believe Mr. Mitchell Greenberg is probably still on the line. I don't know if he was representing some pro se and some kind of element.
Mr. Mitchell Greenberg, can you hear me?
Yes, ma'am. Yes, Your Honor,
I
I can hear
wasn't
you.
done with my. I took a break.
Oh, I'm talking to your brother right now.
That's fine, but I
Mr.
need the
Mitchell,
court to
Mr.
recognize.
Mitchell Greenberg, is there anything, I think the estate was represented here today, is there, I'll give you an opportunity if there's something that you wish to add.
Yeah, I mean, just yes, Your Honor. Thank you. On the record, I just want to let you know I was not aware that any kind of trial happened in March in regards to the adjudication of title or anything like that. As the executor, I'm coming in out of the dark. You said that we could ask for a continuance if I never got in touch with my counsel. He never contacted me in our last hearing. From that last hearing till now, I was never contacted by the attorney after I made requests and asked for a continuance so we could find new counsel. But regardless, I still have to now go back and research what happened in March in regards to some kind of judgment in another trial that I'm not even aware of at this point.
Okay. All right. Thank you. Right. Mr. Daniel Greenberg, I'm going to allow opposing counsel to respond to what
I haven't
said.
finished. I haven't finished.
All right,
You
well,
let them
finish,
speak.
and then we'll let the other counsel speak.
Okay. So again, the predetermined outcome violates due process, as you're aware. So when you came in with the predetermined outcome that the other counsel had, we haven't even gotten to that part. I do want to point out that there was no reason for this. Also is stirring the pot here. There was no reason for Mr. Maher to bring in Sweet Cherry Court into this discussion here, because this is strictly supposed to be about Ackland Avenue. So already you've already crossed the Chinese firewall. Like, you've just proven my point that there is a bias. You're talking about one case in which certain parties are involved, and now you've introduced other people, and they're cutting side deals so that everybody gets my money. That's a little shady. But but you don't know what's being alleged against you. That's not factual either. But let's continue with what the problem the problems were prior to me arriving this morning, and the testimony that you've provided. So Judge Jackson's continued participation amounts to conducting a sham hearing with predetermined outcomes, as she cannot be reasonably be expected to rule against her own prior void orders. Okay. Now, additional fraud upon the court. Judge Jackson's refusal to recuse despite a clear conflict constitutes additional fraud upon the court, as held in Old Wayne Mutual Associates v. Duane. Court cannot confer jurisdiction where none existed, and cannot make a void proceeding valid. I've maintained, and I've asserted, I've given factual evidence, I've given material facts of dispute that what you're trying to do with those orders is not that those orders are not valid, and you are trying to confer jurisdiction where none existed, or make a valid proceeding valid. Now, I that is my constitutional challenge to this court, that I'm being disallowed because you and the opposing counsel have said that because I'm disgruntled, or judge shopping, or venue shopping, that I'm not allowed to make these constitutional challenges, which that's not true. Your thwarting of those, my ability to make those challenges, is in effect a violation of those same constitutional rights that I'm guaranteed. You're trying to prevent me from attacking the void orders. You can't do that. I'm allowed to do that. Now, the situation is particularly egregious given the estate's Marion Wise's recent motion highlighting similar misconduct. As stated in October 10, 2024 filing, there are serious concerns about procedural irregularities and improper rulings affecting multiple parties' interests. As a result, all prior orders must be vacated as void ab initio. Avoid judgment grounds no rights, forms no defense to actions that are taken thereunder, and is vulnerable to any manner of collateral attack. No statute of limitations or repose runs on these holdings. The matters thought to be settled thereby are not res judicata, and years later, when the memories have grown dim and the rights have long regarded as vested, any disgruntled litigant, if you want to call me that disgruntled litigant, that's fine, but I may reopen the old wound and once more probe its depths. That's a constitutional guarantee, and you're denying me that because you think you can, and you know you can't. Further, I need there's more to it. The as I previously requested the disqualification of Maher and Bellamy because of their collusion with Carla regarding trying to push through void orders in several courtrooms. That comes to the forefront again today here now. Evidence reveals recent collusion between defendant Gifford's counsel, John Maher, Nicholas Bellamy, and now presiding judge Ann Martin in interpleader action 230279-2. This misconduct itself disqualifies both counsel from representing Miss Gifford and invalidates any motions filed on her behalf. Um, Again, attorney misconduct constitutes fraud. Since attorneys are officers of the court, their conduct, if dishonest, would constitute fraud on the court. That is H.K. Porter Company Incorporated, Goodyear Tire Rubber. That's in the Sixth Circuit, 1976. So we're talking about a good 50 years of solid case law. The collusion between Maher, Bellamy, and Judge Martin constitutes precisely such dishonest conduct. Loss of attorney-client privilege through fraud. Since Bellamy and Maher helped Gifford conceal fraud, all of the confidentiality is lost. They knowingly pursued enforcement of void orders, colluded with Judge Martin to circumvent proper judicial process, failed to disclose known jurisdictional defects, continued to perpetuate the original fraud upon the court. These are all facts alleged that a court that I've requested a jury decide what the dispute whether or not they are true or false, and I'm allowed to have the jury do that. That's what the jury demand means, is that you present some facts of dispute, and we'll let the jury decide that. I don't want you deciding that. I know how you're going to rule. So there's an ongoing pattern of misconduct. The misconduct is further evidenced by the state of Merriam-Wise's recent filing revealing that this matter, quote, 230279-2 was tried before the court on March 28th without prior notice or opportunity for other parties to participate. This secret proceeding exemplifies the ongoing pattern of collusion and fraud. Now we get to Civil Rule 11 violations. This is where you need to recuse yourself based on the fact that even though you continuously deny your participation in other
Mr.
proceedings.
Greenberg, I am not going to recuse myself, so let's move on from any argument about me recusing myself. If you've got something that deals specifically with the distribution of the money in this case, what we are here for today, you may make that argument, but I have already made my ruling. I am not recusing myself in this matter. So let's move on to whatever other argument you want to make today.
Okay. The conspiracy under the color of law.
And Mr. Greenberg, I may be able to help you out a little bit more. The judgment of the California court, both the trial court and the appellate courts, are valid judgments. The California decision in your divorce case has been properly domesticated in Tennessee.
By you, though.
Appointment of the guardian ad litem was litigated in California.
It was not litigated.
In California,
No.
that's where you needed to take it up. Just let me finish, Mr. Greenberg, and you did.
Your legal analysis is incorrect and unconstitutional.
So, Mr. Greenberg, from this point on, that I'm just letting you know, my decision is that judgment is valid. It is properly domesticated.
And
The
and
appointment
and
of the
and you did that, and you did that domestication. Is that correct?
If you don't like my decision, you can certainly appeal it. There are 2 appellate courts in Tennessee that you can go to, but that is going to be my decision today.
No,
So
just
if you've got anything else
I do.
other than.
But I just want on the record that
You're
you.
free to tell me now.
I just want on the record that you were the one that domesticated the California.
I think he's muted himself, or we muted him.
I'm sorry.
I can't hear you, Mr. Greenberg.
I'm not sure why. Oh, unmute. Okay. Yeah, so I just need you to confirm that you were the judge that domesticated the 20D717.
I'm not going to confirm anything for you, Mr. Greenberg. It's all of record. Everything I've done has been of record.
Right.
So you can look it up. If you have anything you wish to say about the motion for summary judgment that I have not already just addressed with you, you may do so, but your time is running out. So think carefully about what you want to say.
Okay. So I maintain that I still have a right to a jury trial on all factual issues. These matters of judicial misconduct, attorney fraud, conspiracy raise substantial factual issues that must be decided by a jury as previously demanded. The Supreme Court has established, Green v. Thomas, that the Ku Klux Klan Act imposes liability upon any person who, acting under the color of state, deprives another of a federal right. This is the systematic deprivation of Mr. Greenberg's federal right through judiciary and attorney misconduct falls squarely within this framework. So my conclusion is that based on the facts that you're not allowing me to attack those judgments, all those assertions about the funds are erroneous in nature. There were no. I mean, we don't need to relitigate those issues because they're void. For you to issue an order based on those void orders and based on the facts that are presented in the orders that you presented and then domesticated, which I never properly challenged or attacked or had a jury decide what material facts were true or false, is suspicious at best, and if potentially criminal. Again, I am seeking either a trial of these material facts with a jury, award of compensatory damages, punitive damages, and award of attorney costs, injunctive relief, and further enforcement of the void orders. Let's see if I missed anything here. I do further object to the participation of the Cherry Glen Homeowners Association in this particular hearing, and how there was the commingling of funds discussion when you shouldn't be the determinant. You're not supposed to be deciding on both matters, and yet you clearly decided on both matters in an instance where you claim that you don't have any bias, but you just said you're biased. They talked you into being biased. You were supposed, the ruse was supposed to go, you have the 0224 hearing, and then it closes.
Judge, I think I would object. This is, Your Honor, so I can address that.
Yes, Mr. Greenberg, you are repeating yourself, and as just pointed out, I have already ruled on some things that I'm not changing my mind on. You certainly can appeal those to the higher courts. Is there anything different?
Right, but my only concern, Your Honor, is that the higher courts is that the higher courts are what created this environment. So there is my ability to appeal is of little value because the Supreme Court Chief Justice Holly Kirby was the one that decided that you could run this ruse, and Ann Martin participated in this as well. So me appealing to those courts where those individuals were
All right, you
involved
got
in
about
this,
another minute, Mr. Greenberg.
I
Wrap it up.
uh, yeah, I don't I don't speak when you're speaking. I appreciate it if you wouldn't speak when I'm speaking. Uh,
Your time is running out.
Time is running out. So there's a time frame in which justice can be obtained.
If you were making use, Mr. Greenberg,
Oh, this
if you
is
got something different to say, please say it
this is hearsay,
right
conjecture.
now.
This is bias.
Okay, all right. You can mute him and can give the others chance. Mr. Bellamy, Mr. Maher, is there anything you wish to respond to?
Nothing further, Your Honor.
All right, anyone else before we conclude? Let me, I'm going to put down, obviously, and as I'm required to do, a written decision on these matters. I can go ahead and announce to you today that I am going to grant the motions for summary judgment filed on behalf of Ms. Gifford. In it, I will make my findings of fact, etc. But as I have previously said, the California judgment is a valid judgment, properly domesticated in Tennessee. The appointment of the guardian ad litem, which seems to be the main sticking point for Mr. Daniel Greenberg, was appropriate.
I object. That's not true. It's false, patently false, based on the case law that you're aware
There are
of.
no issues raised in his counter complaint or cross complaint that are still before the court. Those have been dismissed on motions for failure to state a claim on which relief can be granted. So the only issues really before this court are the division of the money. If the California court's decision is valid, that makes my decision easy.
But it's not valid.
If you will, again, get your agreed orders to the clerk's office. Mr. Mayor, Mr. Bellamy, if you want to send me a proposed order, I will certainly consider it. I will do my own, but it certainly is helpful to the court sometimes if I get your proposed order to kind of guide me along and make sure I don't miss anything. You're probably much more familiar and have lived with it longer than I have. Anything further, ladies and gentlemen, today before we adjourn? No other matters that the court.
Yeah.
Thank you very much.
So are you not going to schedule a hearing?
All right.
Oh my God.
My glasses.
What a joke.